Welcome to David and David on Real Estate. Join us as we explore the ins and outs of the real estate market.
Good morning and welcome to the David and David on Real Estate podcast. We are today on episode number 93, and we bring to you a very topical issue today, one that a lot of professionals are talking about, and it's the new TRESA legislation that is coming down the pipeline and replacing the current legislation. RECO is making some improvements. So we have our expert in the house, David Korman, with us today. As always, that's going to give us the lowdown and explain to us exactly what every real estate professional out there really needs to know about the new education and the new legislation coming down the pipeline.
Yeah, well, change is generally a good thing, right? Like there's usually some good reason for change. The government certainly thought that we needed some change for this. So we'll break it down as best we can. And I've recently, done a couple of these, this topic on a couple webinars that I've done, and we looked into it. And the first thing I can tell everybody is like, it's not all fully in force yet. So what happened here is there was an act called the Real Estate and Business Brokers Act, which we call REBBA, and that's the legislation that governs your profession, not my profession, but it's what governs the real estate salespeople, the brokerages, etc. So those are registrants under that act. And then back in March of 2020, there was legislation to update this, to improve it. And of course, they changed the name to the Trust in Real Estate Services Act. So the short form is TRESA. So that's what we're calling it. And if you just look at the name, okay, Trust in Real Estate Services. So the whole purpose of this is it's really consumer protection law. That's the reason why they wanted to, the main reason why I think they wanted to change this. It's consumer protection. How do we protect the consumers in a real estate transaction from any shenanigans that might be going on by a real estate agent, by a brokerage, things like that. So you got to keep in mind that's where they're sort of coming from by doing this. So like they put out in their website and their in anything you can read that there was that the changes will strengthen consumer protection and raise consumer confidence in the real estate sector. Okay, like as if there was a lack of confidence and and stuff going on. But we've been in a crazy market, as you know, David, and they keep passing different types of legislation that they think is going to have a certain effect on the actual real estate market and how everybody deals with it. Whether or not any changes they're proposing here is going to have one iota of a change on the actual market, like who knows? Like the market is the market. It gets governed by supply and demand, right? Absolutely.
So David, when you read the new TRESA Act, do you see anything in there right away that, bigger penalties for realtors, bigger penalties for brokerages, disciplinary action? Like let's kind of dive in, and I don't want to take away from your presentation, but let's dive in and kind of explore some of those topics and what are some of those differences?
Yeah, well, the first thing to just point out is there's two phases in this, and the first phase came in a while ago, like it came into force, and that was the phase that allowed real estate agents to incorporate and to run their business through these professional corporations. So that's the one really significant big change that anybody that's out there that's a realtor, should appreciate. That was the one thing that was sort of done for them, okay, to give them some tax advantage that other professions had already been enjoying, and for some reason your profession was late to the game because they hadn't passed anything like that. So that's now available. And as you know, I know many of the agents in your office have taken advantage of it. It's not something for absolutely everybody.
No, it's not.
Yeah. But it's something for everybody to think about doing and consider whether it's good for them, and speak to your tax accountant and determine whether or not you can take advantage of it. Because if you can do it, like it's a great opportunity. So that was sort of phase one that came in, I think, October 2020. Okay, so that's already been in place for a while. So that was huge. I think, from anybody out there that's a real estate. So if you haven't looked into that before, speak to your tax accountant, figure out whether it's good for you. And, my end, we certainly do these, we do it on the direction of the tax accountant, set it up properly, do the legal end of it. But the decision is really going to be done with your tax accountant advisor.
Yeah.
Okay.
Most considering, just very quickly, it's all about how much money you keep at the end of the year. If you're running your real estate practice in a way that there's money left over and you're leaving money in your bank account, then consider incorporating, because that money gets taxed at 10% versus your personal income. Now, there could be a double taxation rule going on. So if you're pulling a lot of that money out to pay for your lifestyle, and there isn't a lot of money left at the end of the day, then there's a double taxation implication that you have to worry about. So very important that you get proper tax advice before you consider incorporating or not. But, for those realtors that have been earning a lot of money and keeping a lot of money on the side to reinvest, to do other things with, incorporation has been a life-saving tax planning strategy. So it's great to see it actually in our profession. That's certainly been a welcome addition.
Yeah, no, I agree. That's really big, and for anybody that's an agent, at some point it might be right for you. It might not be right for you today, but maybe a year from now or 2 years from now, it might be right for you to do. You get the tax advice, you figure out if it's advantageous to you and your lifestyle and your overall tax situation, because why not take advantage of anything that legally allows you to keep more money in your pocket and not give it to the government in pure taxes? Because, each one of you out there is an individual business. You're right. And you weren't allowed to do certain things before. And now so that's a big change. And that came in, and that was phase one, and that got introduced. So that's great. It's been around for, since 2020, October 2020. So that's great. The second phase, which is more the consumer protection aspect of it that we're going to really talk about now, was supposed to come into effect April 1st of this year. And for some reason, and we don't really know why, it has not come into effect yet. It's just been delayed. And I know you and I were talking about it on the phone the other day, and we said, let's save it for the podcast. Because we're just speculating as to why it hasn't come into effect. And I just think sometimes when this happens, there's a delay, is because usually there's a lot of different parties lobbying the government to do something about it. It's something they don't like about it. Different interest groups have something in this act and the legislation that they don't like. So they're trying to get them to amend it or tweak it or get rid of some of it. And so maybe they're just going through that process still. Maybe they've had some, feedback, and they're just not ready to go ahead.
Yeah, I think the Liberal government actually campaigned on this issue, right? And campaigned on the issue of trying to get housing more affordable and trying to get more transparency in the process, right? And David, when I certainly read the TRESA Act, it kind of, it gives sellers the ability to disclose the offer price to other competing offers. So, this whole idea of open bidding is being kind of put on the table, which some people would argue would offer more transparency in the whole offer process. So that's certainly on the table, but it's an interesting market out there that we have right now, with all the inflation news and interest rate announcement, and it'd be interesting to see what they add and what they take away from TRESA in the final draft and the final released version.
Yeah, and look, a lot of what they're trying to do, like you mentioned, is like they're updating the code of ethics, they're updating disclosure requirements, they're weighing in on multi-representation and making it pretty clear, like you got to be damn careful if you're doing that. And we've discussed that in a recent podcast too. Why take the risk? Like, it's almost like it's becoming more and more difficult to do. And as soon as something goes sideways, just by virtue of the fact that you're on both ends of a deal, puts you in the firing line, right? So no matter what the issue is between buyer and seller, it might really be an issue between them, but because you're on both ends of it, and trying to do both ends, it just puts you in the firing line. If it can't be resolved, everybody's just going to blame you. Even though it might be the seller's fault, it might be the buyer, it doesn't matter. They say, oh, I didn't get the proper advice, proper representation. So, some of this is putting a little more teeth into that and making sure realtors are thinking about it long and hard, because sometimes it's just not worth the risk. And there is more, teeth in what they're proposing in terms of if you do something that's offside. And I don't know, you sort of wanted to jump to that, which I can give you a little bit information on the penalties, and then we can work backwards. Where was it? Hang on.
I know that there's a lot more disclosure requirements in terms of direct and indirect funding, where you're getting compensated from. So now they want you to list all the sources of, if you're getting any sort of referral bonuses, where is that bonus coming from? Is it direct? Is it indirect? What's your relationship with that source? So they're getting, a lot into that aspect of disclosure requirements as well.
Yeah, and they're updating the code of ethics too, which there's conflict of interest provisions in there. There's confidentiality provisions in there. There's provisions that say you got to be careful about not obstructing the legislation, and that's if you want to start somewhere, like I look to that part of what they're proposing as something you really got to be careful with, because the best example I can give on this is what's going on in the U.S. right now with the former President Trump and that whole documents case that he's dealing with right now. Okay, so it's one thing, he's been accused of hanging on to certain documents, confidential documents that he was supposed to give back when his presidency ended. But lo and behold, Biden had documents too, and Vice President Pence had documents, and some other people have had documents over the years. But so you're not supposed to do that, right? That's bad. They want the documents back. So that's easy enough. So Biden realizes he's got some, he gives them back. Pence gives them back. Trump took action to not give them back and to make it difficult for them. So the charges that he's now facing, I don't think he's going to get a big conviction at the end of the day on the fact that he had the documents. What he's going to face potential jail time for is his obstruction of the process when they wanted to get it back. And those type of penalties are way worse than the penalties of just non-compliance with something. So when RECO says to you, there's an investigation going on because someone made a complaint against you, and they ask for certain information, you've got an obligation to disclose and cooperate. And if you do that, you should be fine, because you'll have your day in court or a hearing with RECO or whatever they're going to do, and they'll look at you and they'll listen to you and you provide the materials. But the second you resist and not give them everything they're asking for or delay the process, they've got teeth now in their legislation to charge you with obstruction of the process. And those penalties will be way more severe on you than whatever you did on your transaction.
And this wasn't in the previous legislation, David. So I mean, this is this is a big deal, because from my understanding, RECO always had the ability to impose some sort of a penalty on you. But if they can't get to the root cause of the issue because they can't conduct their investigation, then they can't assess a penalty. So, I mean, this wasn't in the previous legislation?
Not to the same extent. So they've added more teeth to this. So you've got, and RECO is the body that looks after the disciplines. They've got a discipline committee in there. So the new powers that are given to the discipline committee are they can apply certain conditions to your registration as a realtor or as a brokerage. They could suspend the registration. They could revoke the registration. So, they've got options there depending on how severe the actions are. So you can't ignore that, right? Like it's important. And again, this is consumer protection legislation. It's important that there's a regulatory body that has powers to control you. It's no different than, my profession is governed by the Law Society. of Ontario. And if we're offside, there's broad powers there to discipline us, which can include the same things. They could suspend me from practice for a period of time. They could ultimately disbar me, right? So you always know that you're not thinking about it every day, but you always know that there is an authority that you have to answer to. So you've got to, you know, we have a code of ethics too that we have to comply with. And every once in a while, certain things get changed in that. So you have to know you have to comply. But where they really put some teeth into this is in that obstruction legislation too. So, so that's where they can really get more aggressive to you. Once they ask you for certain things, you got to be careful. You can't obstruct or attempt to obstruct any person from, one thing you can't put pressure on anybody to not make a RECO complaint against you. Okay. So, you got an issue on a transaction and they're saying, hey, you know what, I'm going to, not only am I going after the seller, but I don't like the way you've dealt with me. I don't think you were acting in my interest, blah, blah, blah. I'm going to make a complaint to RECO. So your answer is supposed to be, okay, like, go ahead. That's your right to complain to RECO, because I'm not really worried if you do, because I think at the end of the day, I'll be vindicated. But you can't be saying, well, you know what, I'll kick something in to the deal, or I'll do something in order to stop you from making a complaint to RECO.
Oh, wow.
That's okay, because that would be considered an attempt to obstruct RECO from receiving information and dealing with it. Like the process is they want people to be able to complain. They don't want, if they have to, and RECO's there to protect the agents and the brokerages as well. It's not like just they're accepting a complaint because they want to come after you. They're going to accept the complaint because they want to show the public that there is a process. And then part of that process is you're going to have opportunity to defend yourself and to state your case. But they're putting more teeth into this, that like you can't obstruct or attempt to obstruct someone from going to RECO to have their say.
It seems that they're taking this whole idea of consumer protection to a whole new level, and really, giving a forum for people to really be able to voice their opinions and complaints and create that due process.
Yeah.
The one
they specifically put in here, David, I'm just going to read this to you. Sure. Registrants must not induce or attempt to induce anyone to withdraw a complaint made to RECO about the registrant. Okay. Sure. So like, that's pretty clear language, right? And I know, like, it's our natural. I know someone wanted to, said, I'm going to make a complaint to you to the Law Society. Fortunately, it never happens. But if they said that, my instinct would be, no. Like, if we can resolve this, how come, why bother doing that? I don't want to go through that process. Like, is there a way that we can work this out? Right. That's sort of your natural instinct to want to do. But now this legislation is saying, no, don't do that.
Wow. So what would happen if a client called and said, hey, you did this and it resulted in a $2,000 cost or incurred cost to me. I'm going to complain to RECO. And you say, well, no, I'm going to go ahead and fix that. Here's $2,000 of my commission. I'm going to rectify the issue. And then the person says, okay, I'm not going to file the claim then. So according to this new legislation, you've done something incorrectly. Meanwhile, you rectified the problem. Right. You made the customer happy. You stepped up to the plate and you solved an issue. And now this legislation is discouraging that from happening. So, when you kind of look at the face value, like, I understand why it's there, because RECO wants to hear all these negative things, right? Right. But now you've actually, discouraged realtors from solving that issue in the first place. Now the realtor is going to say, okay, complain to RECO, see what RECO says. I don't think I was really at fault, and I'm not really going to have any incentive here to make this a positive experience for you because you've decided to go down this path. So now RECO has created a situation where, they're discouraging that positive customer experience thing from happening by a realtor stepping up and just solving the issue on the spot.
No, I agree with you, because look, we all want, whatever the issue was, we want that resolved to the satisfaction of the parties to the transaction, right? Like, that's your job as a realtor. That's my job as a lawyer. It's not to act in our self-interest. It's to act and get the transaction closed and make them all happy. So like you said in your example, like you've now stepped up, even if you coughed money out of your pocket, the $2,000 in dispute, even though maybe it wasn't really your fault, but you say, you know what, to make this deal happen, I'm prepared to kick in something, and so so you get what you're entitled to, and let's get the deal closed, and that should be the end of the story. But under TRESA now, it's no, that we don't want the story to end like that, because if there's a legit allegation that a realtor did something wrong in the process, RECO wants to know about it. Even if it comes to them, they say, okay, the issue's never resolved, but RECO wants it on file that there was a problem. And part of it might just be because they want to have a history of you. They say, oh, this is, Gorski's third time in front of us, or third complaint or something. Like maybe they just want to build up to find out who it is that people are complaining against, because at some point in time, even though it's, oh, complaint against him, oh, it got resolved. Okay. A few months later, oh, there's another complaint against him, it got resolved. At some point, they may still want to step in and look at what you're doing and see if you should be subject to any disciplinary actions.
David, I don't know about you, but anybody that does something wrong that ends up costing them money, that's probably the best way of learning the lesson, making sure it doesn't get repeated again. Like if, for example, realtors list a condo where the hot water heater was rented, and they wrote that it's owned, and then the new buyer buys the condo and, hey, my hot water heater is rented, it's not owned. The realtor ends up paying out of their own pocket to buy out the hot water heater. Let me tell you, they're not going to make that mistake again. They're not going to make it again.
Right.
It was a lesson learned the hard way.
Right.
So, sometimes these things just kind of work themselves out by there being a complaint process in the first place. When you start circumventing that complaint process and forcing people to go down a path that creates a different situation and impedes the customer experience, where the realtor has no incentive to step in there and solve that issue right away, I think that's a dangerous way of moving forward. And I mean, at the end of the day, RECO can come back and says, hey, you know what, you made a mistake, pay for the hot water heater. And at the end of the day, maybe the customer is going to be in the same position. But, these RECO complaints take months and months and months. And now with more of them being encouraged to be made, and that process resulting probably in more complaints being made, I think that process is going to get pushed even further out, which is going to, again, just delay the whole issue and add to the negativity of the consumer experience. So, I mean, that's one of those things that I would encourage RECO to maybe take a second look at. I understand why they're doing it, but I just don't know if it's going to play out in reality the way that they envision it.
Well, maybe that's one of the reasons why this hasn't come in yet, because you look at this as an owner broker and as a realtor yourself, and you're going like this in practical terms, it doesn't really work really well. Like, this doesn't make sense. We want people to resolve the issue. We want the agents to jump in and help resolve the issue between a buyer and a seller, right? And nobody likes finger pointing whose fault it is and blah blah blah, but we want the realtors to stay engaged in the process and try and get it resolved. And this is sort of encouraging people to say, oh, as soon as there's an issue, oh, I can't, there's no reason for me to kick in or try and get this resolved because it's got to go to RECO anyway, so I might as well wait and see what they say and just go defend myself. But in the meantime, the deal's not closing, right? Like, that sort of doesn't make sense, right? But I think you could still, in those type of factors, you could still kick in, you could still try and get the issue resolved. But part of that negotiation can't be, well, if I kick in $2,000, okay, now seller's happy, buyer's happy, we get the deal closed, and everybody please agree that you will then not bring a complaint to RECO.
Right.
That's the part that you can't do anymore,
right?
Which is what you really want to do as a realtor, but you can't say that anymore. So you resolve the issue, hope everybody's happy, and because everybody's happy, they just decide not to go to RECO. but you can't say as a condition of me resolving this, everybody agrees that they'll withdraw any complaints that they might have to RECO,
Right. Makes sense.
right?
Interesting. Very interesting.
Yeah.
That's one that certainly caused some debate among us. So, and that's what we're here for. That's why we're doing this podcast, and that's why we're bringing some of these things to your attention. Is that you're aware of what's coming down the pipeline, how it can potentially affect how we're going to transact, and what the landscape of our industry looks like. And David, I think this is why it's so important for realtors to become a little bit more involved, right? To voice their opinion, to know what's coming down the pipeline, because one rule like this has the potential to really change the landscape of how the consumers interact with realtors, right? Because now the consumer is also not really incentivized to talk directly to the realtor once there's an issue. They're just more incentivized to, hey, I'm going to file this complaint because this is the process, right?
Right.
And we know that open communication and open dialogue is a very important step to resolving the issue. And this kind of discourages that. So, I mean, I agree that, in the perfect scenario, the realtor should still step up to the plate, fix the issue, make it a positive consumer experience, and then, wait out the process and then go in front of RECO and see what RECO has to say about the issue. And, if things go well, then RECO should be satisfied with the resolution that both parties agreed to. But, it's important for realtors to know what's being proposed and how these proposals might change the landscape of what our business and what our industry looks like. I think that's really important.
Yeah, and look, when things go bad on a transaction, unfortunately, a lot of times it's not really black and white,
Right.
as to whose fault it is or who did what. A lot of times it's really gray. A lot of times it's, several parties may have contributed to the problem, even if it's on a hot water tank. What did the seller tell the agent? What was disclosed? Did they not give full information, or did they just make a mistake? But as you and I know from doing this as long as we have, when something goes off, everybody's looking to blame somebody else. There's a lot of finger pointing, and so now you just have to know that you got to be careful. Like still, I think your obligation, and they're updating the code of ethics, and your code of ethics is saying, your responsibility is to your client. It's not to yourself first. Like, you can't be looking at your interests first. You have an obligation to your client. So your instinct is to get the deal done. Like, that's always been my focus in Trem. Something's off the rail. What can we do to get the deal done? Forget about finger pointing and blame. How do we get this fixed so we can get the deal done? Because that's in the best interest of the buyer and the seller, right? To get it done. But you just have to be careful in how you're dealing with that. And I still think you have to do it, but you just have to be careful to say, like, part of why I'm doing this is to avoid you complaining against me to my regulatory authority, right? And if they do make a complaint, you've got to just say, fine, let the process play out. And if you're requested any information or disclosure from RECO, you got to give it to them, because, like I mentioned before, the obstruction part of it is going to be way worse to you than whether you properly, referred to the water heater as a rental or not a rental in the transaction. Like, we all can make certain mistakes, and those mistakes can be fixed. It costs $2,000. Here it is, right? Like, that's easier. You start getting into the obstruction or allegations that you obstructed or you didn't cooperate, then in addition to, you're still going to cost you that $2,000 if it was your fault, but they might suspend you for a period of time or slap you on the wrist this time. But the next time you come before them, they said, hey, we already slapped them on the wrist last time. Now we have to suspend or do something worse to them. So you don't want to be in that position. Right. And you have to trust that RECO's got a process that you can defend yourself and go through that. And even if there's a decision, there's an ability to appeal those decisions. So there is protection there for anybody that's a realtor or brokerage out there by going through the process. So you get your day in court too, so to speak, but you just got to be really careful to cooperate and not try and say, like, get everybody to waive their entitlement to bring an application against you.
Yeah, two very important points. Absolutely, Dave.
Now, some of the other stuff that they're doing in here was, to try and make it clear what a representation agreement is, who you're acting for under a
Yeah.
representation agreement. They call them, it used to be called customers. Now they're calling them clients. For sure, if they were called clients before, they would call them customers now. They just have to change it, right? So, and then make it clear that parties can be self-represented parties, that you are not representing them. And that's something you got to be careful about too in this. You can't let people think that, you're acting for a seller, someone comes in unrepresented, a potential buyer, and you're giving them certain information on this. It's got to be crystal clear that you're not acting for them unless they sign a buyer representation agreement.
Yeah, I think in the old act, realtors cross the line between clients and customers all the time, right? And the new act basically says that, look, if you're working with somebody, you're working with them in the capacity of a client. So they've taken out customer service. There is no customer service under this new act. So right now, if you are working with somebody, they're your client, you have fiduciary duties to them, period, end of story. So you have a choice of having a client relationship or where the other party is self-represented. So they've kind of made that distinction. And I think a lot of realtors were struggling in the old act between what a client was and what a customer was, right? Because if you're working with somebody, they ask you, hey, what price should I put in on this offer? The minute you answer that question, they're no longer a customer. Now they're a client because you're giving them advice, you're giving them opinion. So, and those boundaries were broken literally on an hour by hour basis, so 1 hour, oh, no, they're only my customer, right? Then they ask you a question and now you've answered it. And, oh, sorry, now they ventured into being into a client relationship. So, to really draw a really thick line in the sand, what I think RECO's doing is they're saying, hey, listen, if you're working with somebody, they're a client, period. So now both the consumer and you know exactly, what that client relationship looks like. Whereas before it was so convoluted and so many realtors stepped over that line by answering questions, by giving their opinion, by giving their advice. Very few realtors really, especially in a multiple representation situation. In a multiple representation situation, both clients are clients, but in a situation where one was a client, one was a customer, it's hard to draw that line in the sand and not cross it over. So I think with this new act, they're really trying to make it black and white of what your representation entails. So they're basically saying, listen, if you're working with somebody, it's a client relationship, you have fiduciary duties, or the party can be self-represented where they're not your client. You can't answer any questions. You can't give advice. You can't give opinion. And you really have to draw that line in the sand.
Yeah. And that's the challenge. Like, exactly where is that line in the sand and how that's going to be interpreted. And the key element from what I read in this is reliance. So as soon as you're giving some information that party might be relying on in making their decision, that's when you're probably crossing the line. So you're allowed to provide certain assistance in the process, but you can't be giving them information where they're relying on that information to make a decision. And they haven't given a lot of examples, but one example they said in terms of what is assistance that's permitted, if you're assisting a self-represented buyer to show the property, to show a listed property, okay? You're not commenting on value or anything like that. You're just providing some assistance that way. So something like that might be permitted. But if you're suggesting a price, that's clearly beyond assistance. And now that party is going to be relying on your expertise in something like that and putting in an offer. Okay, so that, that's sort of a clear example of where you'd be crossing the line. So you got to be very careful. So because people are allowed to be part of a transaction, they're self-represented. If they're self-represented, you can't cross that line to make them rely on information that you're providing them, or any opinions that you're providing, or your expertise, because now you've just taken them on as a client.
Mhm.
Like sometimes unbeknownst to you, or not on purpose, but you have.
Yeah. And David, are you aware, did they abolish multiple representation in BC?
In BC, no, you know what? I don't know. I don't know
Yeah.
if they abolished it completely. It's, and like I've talked, about this and other things. Like we're always, it seems like things happen in BC first, and then Ontario looks at it, and then they say, hey, Matt, that seems to be working over there. Let's bring that in here.
Yeah, but all I was going to say is that, we're pretty fortunate to still have the ability to represent unrepresented people in the transaction, because at one point there was talk about not allowing any multiple representation. And, I believe, OREA really lobbied against this, and they basically said that by eliminating multiple representation, you're actually taking choice away from the consumer. And that choice being to go to the listing agent, have them represent them, right? So it was, nobody really thinks about the consumer as realtors. We tend to kind of, look at the industry a little bit differently. But I think, looking at it from that point of view, and making sure that the consumer has the ability to choose who they want to type up the offer and represent them in a transaction is a really important way of looking at it. So I give kudos to Tim Hudak, to REA, to all the lobbying groups for, making sure that we still have that ability here in Ontario. And I think it's an important consideration. And I know, David, all the pitfalls that come with it, but I think when you look at it from the consumer choice point of view, it's absolutely the right decision.
Yeah, so I think that's clearly been a decision now that they're going to continue with it. Like under the old act, under REBBA, multiple representation was permitted, as long as there were certain disclosures made to both parties, right? There were certain rules. So that hasn't changed under the new act, under TRESA, but what they've done is they've sort of beefed up some of the disclosure requirements. So they're just trying to clarify what has to be disclosed to whom and how and when, and just to beef that up a little bit. So they're not, taking steps to get rid of it. They're saying, fine, if you're going to do it, because they recognize that it does make sense in some fact situations, and it is choice by the consumers. Part of their protection is to have a choice. So they're saying, fine, if you're going to do it, be careful how you do it. Make sure you disclose properly. Make sure everybody's aware that you're on more than one into this, and everybody understands what the rules are. And as long as everybody clearly understands what the rules are, then there shouldn't be an issue. So that's sort of where the change. So they're just trying to beef up the disclosure requirements a little bit.
Yeah. David, did anything surprise you in the TRESA Act that you thought would be in there and it wasn't, or did anything kind of surprise you in there that you were surprised to see in it that you didn't think would be in there?
No, I wasn't really looking for certain things to go into it, because my sense, I deal with this industry day in, day out, with agents, the best agents, the worst agents. Failing, the only thing, if they would have said, an agent, you can only be a licensed agent if you're devoting your full time and attention to doing it. You cannot be a part-time agent. That's something I would find really significant, because I think that would really help the industry. No, really, when I think of it, because I see that most mistakes that I come across on transactions are not done by these seasoned veteran pro realtors that are doing this day in and day out. Like, we all can make a mistake, a careless mistake. We didn't describe the hot water heater properly, or we wasn't clear in the information, or we had a drafting. Anybody can do that. I'm not talking about that. But part of what I find a problem in the industry is the part-timers that aren't on top of the forms and the latest changes and the rules and the disclosure requirements. And some of them just don't understand the transactions properly. I still see agreements of purchase still to purchase a residential condominium unit that's not done on the right form.
Yeah.
That's done on a form that's got nothing to do with condos, and there's nothing in the agreement purchase and sale that says they're entitled to get a status certificate. When I see stuff like that, it's like, I want that agent out. I'd love to see legislation that doesn't allow that agent to practice.
Yeah.
Right.
But
it doesn't work like that.
Sad part of that reality is that there's two agents on that transaction. So,
that's true.
Two agents missed
That's true.
Even more shocking.
That's true. Right. So, and I never saw anything that was going to, propose that, you've got to be, so what they do it is a different way. It's, if you're not being a proper agent and you're making those type of monumental mistakes because you're not doing this full time and you're not paying attention, you're going to run into a problem of file and you're going to come before RECO because someone's going to make a complaint, and you can't try and head them off from making a complaint, and those complaints will come in, and then they have the opportunity to discipline those part-timers, right? And those realtors that aren't taking their profession seriously enough by making an attempt to do it. Like, if you come in, if you make a mistake in a file and you go before RECO and they say, oh, you've done 1,000 transactions in your career and you've never made those kind of mistakes and you always do, and this is just a one-off type of thing, they're not going to hammer you. They're going to make sure you understand what you did wrong, you tried to fix it, or you did fix it, and they're going to look at your history, and then off you go, right? So there is more teeth, which I think is good for them to go after agents that are really doing a sloppy job, and they don't care. They're just, they're chasing the commission instead of trying to act in the best interest of their client. So, so there is enough teeth in this to go after to discipline those that are really repeat offenders. And, I think anybody that's very professional about their craft as a realtor has nothing to really worry about.
No, I agree. And I completely agree with you about the part-timers, David. I mean, our industry is full of part-timers, and I think as the market shifts and it becomes a little bit more expensive to maintain your license, I think we're going to see that change. But we need more education, we need more training, and we need to make sure that if we do allow part-timers in this industry, that they're represented and managed and under the direct supervision of someone that can really make sure that they're not making these type of errors.
Yeah, and look, it's no different than in my profession. We have part-timers too, in terms of how I would define them as part-timers. Like, we have some people who are general practitioners still, that they're in court, they're doing litigation, they're doing family law, they're doing anything that'll come to them. And as part of them, they're doing a few real estate transactions. I hate getting those people on the other side of my transactions, because at one point in time, we could be general practitioners in Ontario. That ship has sailed. It's really, really hard to be a general practitioner. You can't do a good job as a litigator. You can't do a good job as a family lawyer. You can't do a good job as a real estate lawyer if you're trying to do all of it. There's just too much going on in each of those respective disciplines. So I find it very problematic on transactions when I'm dealing with a lawyer trying to close a deal and he's in court and I can't get him. And then when I do get him, we have an issue on a file and he's never experienced it because he's doing, 2 or 3 real estate closings a month, as opposed to, my office is doing a couple hundred real estate closings every month. So, and we have a collective experience. I'm not involved in every single transaction, but I do know every single transaction that goes off the rails. When an issue comes up, we share that information. We all gain by the experience of those situations and know and discuss it and know how to handle it. If you're doing 2 or 3 transactions a month and most of them are going smooth, you don't know what to do when something goes sideways. So, like, part-timers don't help any industry, I don't think.
Yeah, I completely agree. That would have been a welcome change to at least, beef up some requirements around part-timers, but we definitely did not see that in the legislation, but it's still being reviewed. But I'm not going to hold my breath on that one.
No, but there's other ways they can get to it, because if complaints are happening against those people, and in some ways this legislation is encouraging the consumers to make those complaints and telling you, if a complaint is threat, you can't do anything to try and stop that process. So I think at the end of the day, I think they're hoping they will get more complaints and they can take action against those repeat offenders and those parties that aren't dealing with it properly, and they'll either suspend them or discipline them enough to the point that they're going to get their act together, or they're going to get them out of the profession altogether, because it's going to, the decision will be made that they could revoke their license, or it might just be the realtor themselves that says, this isn't worth it for me on a part-time basis. I'm going to keep getting myself in trouble. I'm going to go do something else. Right.
Right. So, David, is there a process for realtors to be able to comment or share their opinion or get involved in the process?
Yeah, I haven't really looked, if there's something like right on the RECO site that allows you to comment or weigh in or something like that. I know that some, just do it through, contacting their broker, and their broker is, I don't know if you're getting it and then you go to, you're part of Sutton Summit, and sometimes you voice it to Sutton Summit, and sometimes it's it's the head office that weighs in and lobbies. But OREA has processes available on their website that you might be able to weigh in on. You can look at the RECO website. I haven't really checked it out myself to see if there's a way to directly do it, but it's certainly worth doing. It's worth having the conversations.
Yeah. I think one of the best ways would be to reach out to one of the directors of RECO, and they're listed right on the website, and email them, and they would be the people that would have and be able to get you in touch with the right process and the right people to be able to voice your concerns. But I would certainly take a really good look at the RECO website and take a look at some of these proposed changes, because they can make a big difference to how we transact ourselves and how the industry interacts with each other in the long run. I think, it's really important that we know what's being proposed. We understand the consequences of everything, and we voice our opinion to make this industry even better.
Yeah, and at the end of the day, like, some of this makes sense, okay? Because consumer protection legislation, it's to try and make the public have confidence in your profession. Okay, that anybody who's acting as a realtor, or if you're acting as a broker or brokerage, that there's professionalism involved, and that you have a code of ethics, and that you have a discipline against you if needed, and there is a process, and all that's to create more confidence in the market. So when they're hiring a realtor, they're hiring someone who's a trained professional, that's subject to a code of ethics, that's subject to certain rules, that's going to comply with it, so they don't have fear of, are they acting in my interest, or are they acting in somebody else's interests? Okay, because they should have confidence they're acting in their interest. And if there is anybody else that they're also acting for, then that has to be fully disclosed and discussed and agreed upon by everybody. So, like, all that's sort of a good thing. Anything that makes you a better professional is a good thing. If you really think about it, right? You just have to be careful that you understand the change, the nuances, and what you have to do. And I think most of it won't be that difficult for anybody to do. It's, some of it is sort of common sense and disclose, and we'll see. But obviously, they're getting some pushback on some of this, and I think that's why there's a delay in implementing it, because they got to be tweaking some of it. So, those that are contacting RECO or contacting the directors or doing something, they're probably having some effect, because, there's got to be a reason for the delay. Otherwise, it was a year and a half after phase one, and they didn't come out with, they had a year and a half to play with it. And then they said, okay, we need more time.
Yeah, no, absolutely. And listen, I mean, I think this is important, and it's important that you voice your opinion, and that you pay attention to this stuff for sure.
Yeah. And we'll address this again at some point down the road when it does get implemented, and we'll see what of any of this got tweaked or changed, if there's anything significant that happened. So, at some point we'll look at this again, down the road.
Yeah, and David, your office does webinars for brokerages on this topic as well. So any brokerage that's listening, contact David Korman's office. They do an excellent presentation to the agents on this as well. And David, you can certainly make yourself available for those.
Yeah, thank you. Yeah, I've done a few, like for your brokerage. We did one a couple weeks ago. I've done a few others, and there's other lawyers in my office that have been doing some as well. So, it's a bit of a moving target right now, but we can only talk about what's being proposed and what's in the legislation. Then we'll see if that gets tweaked down the road. But we just have to be aware that there are some changes coming, and and how that's going to affect everybody. So, and I think, look, like this is coming off, like how many years now have we had a market where there's been a lot of multi-offer transactions, and that sort of fuels some of this, because when there's more than one offer coming in, what can an agent say? What can they disclose about price or about other offers that are coming in? Like what should they be disclosing or what shouldn't they be disclosing? And there's different opinions on that, right? Like I know, like from your opinion, like should the price be disclosed? I got an offer that's a higher, you say I just got a higher offer, or do you have to say, I got an offer that's $10,000 higher? Like what's better?
In my opinion, is you need to be fair and transparent in the process. So if the seller says, hey, I give you permission to disclose the price, if there's 5 offers, then you need to disclose the price to everybody. So all 5 parties have the same experience and the same shot at getting the information. Like everybody should have the same information, right? If the seller says to you, hey, disclose the price to him, but not to him, and maybe talk to him, but don't talk to him, that's where that's where there's a breakdown of the process. But as long as everybody has the same information, then I think nobody can complain, because nobody can say, hey, the process is different for him than it was for me. So I think that's the key to making sure that, we protect the consumer, that everybody has the same information and everybody's treated the same way in the offer process. And as long as that is happening, then I think, you should follow the lawful instructions of your client. And I like the new TRESA Act, because the TRESA Act gives sellers now the ability to say, hey, I want you to disclose the price, because I think it's going to give me an advantage. If everybody's aware of what I want, then we're going to get to, that milestone faster. Now, we know as professionals that always doesn't work that way, but I think having that in your tool set and in your arsenal, and now being able to do that is an important consideration.
Yeah, no, I agree with you with all of that, but you have to keep in mind too, like, I think it's good for it to be a fair market process.
Yes.
And as part of that, it's not always the price that wins.
No.
Right. So people get focused on the price, and I wonder what the other guys pay because I'll offer more. Well, the reality is you could offer more and beat the price, but you still might not be successful, because if the agent sells is doing their job properly, they're also trying to qualify the buyer, like who's got the best ability to close, who's got the best ability to waive the conditions, whatever conditions there might be, and who's really got fun, and who do I want to deal with. Right. Because I trust this other agent, this other person I think is a part-timer, doesn't know what they're doing. I can see all the mistakes they've made in their offer. Even though the price is best, I think we're taking a risk by accepting that offer. We might have to give up a little bit on price and go with a better offer that's a cleaner, with a professional agent bringing it to us that has probably done their homework and qualified their buyer. And your advice to your son might be, no, let's take offer B, lesser price. It's a better offer. You're going to close. You're getting a fair market price. Let's do that. Right?
Yeah, David, I just went through a personal transaction. So I'll save this story for next time, but remind me how we went with an offer that's $25,000 less, but it was the right decision. So, and no regrets. But
That's a
I'll remind me next podcast. I'll tell you the whole scenario through exactly what happened, because it was just solely based on the ability of the buyer to close and their financial strength. But we'll get into it next podcast. I'll explain the whole situation, exactly what happened, and I'll tell you guys why I made the decision of accepting an offer that's $25,000 less.
And you know what I call that? I call that being a professional. Like, that's doing your job properly. It's not price that should win out all the time. We've talked about this before. There's a number of factors, and you're not doing a service to your client if you're just focused on price, especially in a multi-offer market.
Yeah, and in a rising rate environment too. Like, everybody needs to be aware that on July 12th, they're gonna, the Bank of Canada is gonna convene and make yet another interest rate announcement, right? So, and we don't know what the outcome of that announcement is going to be. And yes, if people are pre-approved today, then they're locked in. But, this will change how and what people can afford and what their carrying costs are. And it will have an impact on their ability to close if the closing date will be after that date. So, and consumer confidence is huge too. Like, what if that buyer turns around and says, what, I'm renting right now. I'm just going to walk away from my deposit, continue renting, let them come after me, right? And as a professional, you don't want to put yourself or your clients in that situation. But we'll get into all the details. I'll share with you guys exactly what happened, and I'll tell you guys the whole scenario on podcast number 94. Stay tuned.
Great to have a teaser for the next podcast. So I'm looking forward to it myself.
All right, David. Well, listen, thanks so much for your time. Thanks for explaining everything to us, and looking forward to the next podcast as always.
Yeah, always great to be with you, David. Thank you.
Have a great week, everybody.